for people who are thinking about a short sale or foreclosure. Basically, if you're in those counties like what we're seeing right now in San Bernardino and Riverside and starting in San Diego, I mean, we've got a lot more short sales. We're up at 20 or 23. Last time I looked, there were 2. So if you're in those areas where there's builders, or you could have taken out second loans and your equity's tight. But if you're in those areas where the builders are now cutting below your prices, and you're wondering what you can do a lot in California. We're going to go through this video series, but you should know that we have a lot more leverage in that now. We can delay foreclosures so much longer, and we're going to use that as a hammer to protect people's credit as best we can. And we're going to use the laws to make sure that they get the workouts that they want. And one of those laws, one of the granddaddies, the one we used to use at UpsideDownRealEstate.com, it was one of the most searched terms on my website, CCP 580b. And I resurrected UpsideDownRealEstate.com, this time in WordPress over the weekend, and 580b already ranked. The website had been follow for a while. And I should say that it didn't rank on a common term, but it's indexed. And so let me pull it up right now. And the reason why I started here is because we did already get a search or 2. We got short sale realtor and this coming to the site already. I was quite impressed. And we had like 120 clicks in the 4 days the website's been up. But some of it came from Blogger, where I had started in 2007 with posts, but it's showing me there's a bunch of searches going on. So we've got 580b, the gold standard. So I've done this a few different ways, but this should be pretty good. And let me scroll down. So 580b is, and I wrote the strongest consumer protection law for California homeowners, because if you fit into it, it's just solid. Most of the banks, if their collection departments don't understand it, by anytime a loss mitigation person at the bank has been doing this for a while, they come to understand what a non-recourse loan is. That means the bank can't go against you for your deficiency for what you owe the bank once the bank forecloses. Non-recourse is also very, very important to the IRS. The IRS says when you have a non-recourse loan, because you don't personally owe for the money, when the 1099-C comes out, the loan forgiveness, tax reporting by your lender, when it comes out as a 1099-C, you don't have to report that as income. Or in a recourse loan, you would, unless you have another way to exclude it. So in short, with respect to taxes, you still have to worry about capital gains. But if you have purchase money loans, you're not going to owe the lender money, regardless of what they do. Foreclosure, short sale, you just walk away. You walk away strategically, strategic defaults. We did tons of those. And even, just in any circumstance where you're not committing fraud, 580b will protect you from the bank, and it should protect you from the IRS. So now you do want to make sure you fit within it. So, you could come down on the page and go to the exact statute and see, was my home 1 to 4 units? A dwelling is something you live once or twice. Dwelling came up. Was it a dwelling in my practice between 2008 and 2015? But if it's a house, you're fine, right? So it really, that's what it is. 580b, purchase money loans, non-recourse. So you're going to be protected from the banks if you fit within it. You're going to be, and so if you're an individual homeowner, you use the money to buy the home. It's 1 to 4 units in California. You fit. Are there exceptions to the rule? Yes. You should read the statute, talk to a lawyer. But if you're fitting in there, you're looking good. And 580b, like I was saying, the banks know about it. So it gives you leverage to get the kind of deals you want sometimes. Now, one of the things I would say, let's say you're in those areas where the banks are already undercutting, the builders are undercutting you, and you're like, well, I have a little bit of equity, but I don't want to go negative, but I want to get out. I'm done with California. I'm done with these high-priced properties. I'm done. I want out, but I don't want to destroy my credit because when I move, I want to get a job and live elsewhere. Well, that's where I'd say 580b is your friend, because the banks understand it. And if you write letters and explain the law, as a lawyer, what I would do is I'd write a letter to them. I'd say, we're only going to be a few $1,000s short. We're not going to go in. We're going to start off not going into default. And because we have purchase money loans, you're not going to be able to get more than this. And if you play ball with us now and take it back early, and we do all these things, you will be protecting your investor. And I'll do it on my letterhead. If I don't get anywhere with the negotiator, that initial one, I'm going to ask to go up to their legal department. I'm going to ask them who their investor is. I'll talk to the investor. I'll talk to them about their fiduciary duties. And like this works sometimes. We got people to be able to do a short sale, or the bank would accept less than they were owed and not damage my client's credit, because we could leverage these laws and others. There's so many laws now that's what this series is about. I'm going to go through the laws because an educated consumer is our best customer. So you're going to see how they work for you. Now, your next question would be, well, John, I originally had, let's say you've had the house for a while, a $500,000 loan against the property. I was paying for a while. It went down to 400. And then I refinanced because we got those low rates 3-4 years ago, or around COVID time. And we took 100 out. So we're back up at 500. It was 500 when I bought it. It was 500 when I refinanced. Am I covered? And I would say I wouldn't give up on the argument, but I would say that my research indicates, because this law changed to include cash out refinances in 2013, and it says to the amount that it wasn't a cash out, they use the word advanced, but to the amount that it's not a cash out, you're protected. So by the statute, you would believe that 400,000 would be protected and $100,000 could be recourse. Now, what would that mean? Well, that would mean that if you took a foreclosure, the bank, the 99.9% of the time, the bank's going to do a non-judicial foreclosure. And because of our rules, and we'll discuss these, but like the security first rule and 726D, the one action rule, and 580D, it's 726 and 580D. When your bank does a non-judicial foreclosure against you, there can be no deficiency. So regardless of the purchase money aspect, even though you're 400,000 purchase money, 100,000 recourse, the only way the bank's going to take your property back, and if they're doing it judicially, call me, because they're not supposed to. They'd have to really come up with some unusual title problem, and you're not an individual and covered by the laws, because a few times they do that. People from out of state, banks that didn't know the rules, or they did it rarely, they could sometimes start a judicial foreclosure, and you're like, what are you doing? If we took you to court on this, you might have to proceed for a money judgment, and the client keeps the property. These laws are serious here. You better hire a team that knows what they're doing, and they'll go back and do what they're supposed to. But they foreclose. They cannot pursue. The bank can't pursue you for the deficiency. You would argue the money goes back to the bank in full satisfaction of the debt, but I'm not sure that if you go reading the IRS, I mean, we'd make that argument for you. I'd even put it in writing, but the IRS might state that you might owe taxes on, well, you get a 1099-C for perhaps $100,000 if it was very short, maybe 50, but that 1099-C some of that could be considered as income by the IRS. There's rules for how they determine, when it was going to principal, what was written down, but let's just say 50,000 of it would be income. You might have to put that on your taxes if you don't have other ways to deal with to write it off. So you might be insolvent. There's lots of things you could do. However, that's why we have a process where we go through all your loans. We look at what laws apply. We figure out your what you owe to the IRS. We figure out what you would owe to the bank if particular actions are taken, and we figure out how we can protect your credit or minimize the risk to your credit. And so I would say to those people where you're dealing with a recourse loan, you might not want to let the first foreclose if you're concerned about the tax consequences. And there are other remedies. The next remedy will be the short sale law, 580E. And 580E for people with recourse loans might be a very good law. We'll find out in the next video. Now, you can rely on the algo, or you can, and I haven't done it yet, but soon at upsidedownrealestate.com, because I saw that it worked. I wasn't sure that this was going to work. But when I typed in my website in 580B, although there were 4 or 5 pages they could have pulled up, they pulled up this one. So I'm going to make a video series. One will be for short sales, one will be foreclosure defense, and one will be for zombies And I really think deed in lieu's are looking good. Deed in lieu's were great in the beginning, 2008, 2009, 2010. And I'm thinking deed in lieu's are going to be good again for a while. So, deed in lieu's instead of foreclosures, we're going to be covering all those things. But this is going to be about a 7-part video series with supplemental videos. And so I would go to upsidedownrealestate.com, upsidedownrealestate.com, and click on the video series links. And eventually they may just show up in the search. Thank you. Talk to you later. But let me just say another thing, because I really know after seeing the stats, and we're going to be doing the stats, some of you are ticked right now and you're worried about your future. I would say before you agree to do a short sale or sign any listing agreement, look at your potential for a loan workout. We have developed a no default short sale or no default loan workout where we're going to work with you. And if we even have to reduce our buyer agent commissions or our commissions down to almost zero, we still want to help you avoid having to do a short sale. I'm a member of the CRMLS. CRMLS covers the vast majority of California. It's the largest in the nation. And if you're willing to do a little work on your file, like have an open house in the first Saturday or two so we can get a lot of exposure, we'll give you the materials you should have, or we'll explain to you. But if you're willing to help sell your house, we're willing to reduce our commissions to help you avoid a deficiency. We're calling it our low equity home seller. We would also concurrently, like if you're like, I don't want to waste time, I want to get this over with, we could concurrently start the process at your lender. There are so many laws now. Like in the past, a lender only would have had to wait maybe a month. They didn't always start quickly. They sometimes send out a few notices, but the foreclosure timeline was about 50% back in 2013 of where it is now, because there's federal laws that extend out 120 days. And we also have other rules like 2924 that we can buy another 90 days if you time it right. Part of it has to do with listing for a short sale and getting an offer and presenting to the bank. And as a lawyer, I would stop the bank from dual tracking a foreclosure and the short sale, and they have to consider it. So we can now spread out the foreclosure process for over a year. You can't tell me that they should be saying, oh, we want this person to go into over $10,000. We're willing to make this person pay lates. And then, because if they're going to force my clients to be late over $10,000 or $20,000, I'm going to tell them right now, I'm going to tell my client that we have to worry about this bank. We have to worry about waste, and that they're going to put lenders in, and it's going to take that bank's not going to get that property back for a year. I mean, this would be with you. And I look for all the reasons why maybe they've not serviced the loan well. We'd send them accounting requests for all their notices, and we would make this very, very difficult. And I'd say, look, I'm an attorney. I'm writing you all the rules and all the reasons why your investor is being crushed by your decision, and they're gonna net far less than the $20,000 they're losing now. So we're disputing the debt. Let's settle this. My client's in good faith getting this done for you. If you reject this now, your investor's not going to see money for a year or longer. There's going to be renters in there. They're going to have to follow different foreclosure laws for renters. You guys are making a very bad decision. By the way, who is your investor? We'll send them. It's not a subpoena, but it's pretty strong. We have all sorts of tools to help you. So if you want to avoid a short sale and you've got laws like 580b in your corner, I think there's a very strong chance that we could either get them to agree to a short sale or a deed in lieu. And a deed in lieu we'd have to negotiate the credit results too, but we could. I mean, that's part of the deal. We're trying to say, look, we don't want you to take any lates, so there should be no credit hit. So if you take the deed in lieu back now, you're going to realize $150,000 more than if you wait for another year. My name is John McConnon. If you want to go to upsidedownrealestate.com, we're more than happy to take a look at your position, give you a recourse, non-recourse analysis on your loans, and we'll talk to you about your best strategies. Thanks. Talk to you later. Bye.